Welcome, and thank you for joining our webinar. My name is David Heckler. I'm the Editor-in-Chief of Metropolitan Corporate Counsel. We have a great webinar planned for you today, presented by Julian Ackert of iDiscovery Solutions and Drew Sorrell of Lowndes Drozduk. They will be talking about a very hot topic, data breaches, and more specifically, how your company can deploy legal and technical resources to contain and mitigate them. Before I turn it over to Julian, I'd like to pass along a few tips to help you make the most of your experience today. You'll notice that there are widget icons at the bottom of your screen. I'd like to draw attention to a few of them. The TV screen icon is for the presentation itself. If you were to close the slide view, just click on that and it will reappear. Also, to make the slide bigger on your screen, just click on the larger square on the top right corner of the slide screen. You can move and change the size of all the boxes open on your screen. The Q&A icon you see down on the bottom is where you can type your questions during the presentation. We will be keeping track of your questions, and if they make sense to address on a specific slide, we'll do so. Otherwise, we will respond to your questions at the end. If your specific questions are not addressed during our webinar today, the appropriate person will reach out to you individually at a later time. Also, if you're having any technical issues during the webinar, feel free to type your concern and someone will reply to you. The green icon with the folded paper corner, offers reference material that you may want to check out later. At the end of the presentation, a survey will pop up with a few brief questions. We would very much appreciate it if you could take a minute or two to complete this very short survey. Finally, as a reminder, this presentation is being recorded and will be made available to all registrants. Thank you again for joining us today. Now I'd like to turn over the mic to Julian Ackert, who will be leading off the presentation. Julian?
Thank you very much, David. Good morning or good afternoon, everybody, depending on where you are sitting in the world. I wanted to first talk a little bit about who we are today. My name is Julian Ackert, as David mentioned. I'm a technologist, so I'm coming at this presentation from the technical side. I received my Bachelor of Science in Computer Science from the University of Virginia, and I started working in computer forensics in the early days back in 2003. During that time and in my early days, I was a boots-on-the-ground resource for forensics, forensic investigations, any type of activity related to that, and I am now a testifying expert in what I find, with a specialty on insider breaches and theft of trade secrets and intellectual property. Drew, do you want to talk a little bit about yourself?
Sure. I'll be brief, and as an attorney, I always like to talk about myself. I am a lawyer. I'm not a computer technologist as Julian is. I'm instead a person who, and I won't tell you how many decades, but for decades has enjoyed playing with computers, building computers, programming, and things like that. I'll tell you, I'm also very proud to say that I can program in BASIC, and that is the limit of my ability to program. Now, that having been said, I'm also the same guy who gets stuck in the room with the IT department when somebody has a question that needs to be explained to the court, and we have to have an affidavit or we have to have a technical argument in court as to what happened, what can possibly be done in a technical sense versus a legal sense, and so on. So that's my background.
Thank you, Drew. So let's talk a little bit about why we are here. Why are we talking about data breaches right now? And I'm going to talk a little bit about the statistics from Ponemon Institute. For those of you who don't know, Ponemon Institute was founded in 2002 and has become a widely referenced customer study base on cybercrime costs. So I figure it's important to talk about those right now. First and foremost, in 2016, the average cost of a cybercrime is $17 million. That's a big number. But I tell you, what's more surprising to me is the rise in this average number from 2013 to 2016, up 66%. And this hockey puck trajectory is one of the reasons why we're here and talking about this today. It's not surprising what the top three sectors are with the highest costs: financial services, utilities, and energy and technology. Each of the institutions in these sectors hold very valuable data and control extremely valuable assets. What's not on this list that I wanted to highlight is that the legal sector is actually making a rise as well. A couple of cases to point out, or events: the U.S. v. Hong et al. Matter, where the defendants stole mergers and acquisition documents from law firms and made trades based on that insider information. Pretty significant case out there. Many of us have also heard about the Panama Papers, which was a law firm's entire email server that was hacked and all the information that came out of that. So it's becoming very clear that information is a valuable commodity, and the likelihood of a cyber attack is really not a question of if, but a question of when. Here I'm going to turn it over to Drew to talk a little bit about the legal environment of where we stand right now.
And I know that we have some attorneys that are on the line today, and if you're in the privacy and technology area, this is going to be to some extent information that you probably know. That having been said, I think it's important before we talk about what to do in a data breach to understand what the legal environment is in which all of the businesses in the United States, at least, and to some extent overseas, operate. And so the first point you'll see is that I've put in this 60 actions since 2000. And what I'm referring to is that the Federal Trade Commission, which describes itself as the chief federal agency on privacy and enforcement, they have taken 60 actions, enforcement actions, since the year 2000. And there has been at least one challenge under the case of FTC versus Wyndham as to whether or not the Federal Trade Commission actually has the authority to enforce cybersecurity and privacy issues as part of the, I guess you would call it, the general rubric of protecting consumers in the United States. And the Third Circuit pretty much definitively identified or answered that question and said that the FTC does have authority and that they are fully capable of going out and protecting and prosecuting throughout the United States cases and taking actions to enforce privacy rights and policies. Now, with respect to that, it's important to note there are some, I think, interesting cases that the FTC has brought, and it gives you a little bit of a flavor as to what the FTC finds interesting or not from an enforcement perspective. So the first one is the Ruby Corporation, which, if you're like me, you probably don't know what the Ruby Corporation is, but when I tell you that that's the parent corporation for the Ashley Madison website, that may ring a bell, if for no other reason than it made the news not too long ago. In December of 2016, the enforcement action was brought against them by the FTC, basically with the allegation that Ashley Madison failed to require some of its providers to implement reasonable security, failed to train personnel to perform security tasks, and failed to implement reasonable access controls. It's notable, too, that one of these services that Ashley Madison was selling for a $19 premium was the ability to be forgotten. And the idea was that if you paid Ashley Madison $19, that your name and information would be completely deleted from the website and from their data banks, such that you would not ever be known if there were some type of issue. The problem is that it was sometimes taking up to a year for that information to actually be eliminated from the data bank, such that when the breach occurred, you had folks that were breached that had paid the $19 premium and not, in fact, been forgotten, so to speak. Another interesting case, and the reason I bring this case up is because I sometimes hear well, we're a small company or a medium-sized company, and so this isn't really as applicable to us, and the FTC is not as applicable to us. The LabMD case is, by definition, a small to medium-sized company, and enforcement action was brought against them because one of their employees was using a peer-to-peer network to share information. Unfortunately, the employee failed to exclude from their sharing their My Documents folder on their desktop, with the net result that 1,718 pages of customer data were shared over the web. Notably, there was no tangible evidence of harm with respect to the information that was shared, and if my memory serves me correctly, I don't think there was ever any proof that it was actually accessed by anyone, proof being different than was there a chance. Now, it's interesting because the FTC went after this mid-level corporation for what is essentially a negligent act versus some kind of malicious act. And it also has now resulted in the LabMD Corporation going out of business into bankruptcy, although as I understand it, the case still trugs on. Practice Fusion is somewhat similar in that they did kind of the opposite, and that is they collected information from consumer surveys. They took 600,000 reviews of folks with respect to their experiences with healthcare providers and did not, according to the FTC, adequately let people know that when they were providing the information, it would be published online. That then resulted in an action where the FTC basically said it was a problem with the actual amount of disclosure as to what you were going to do with the data versus some kind of inadvertent breach. So the FTC takes what I would say is a wide interest in both sizes of companies and the actual, I guess you would say, mental state as to why they were doing it or not. And so even if you didn't intend to do it, the FTC will still perhaps take a look at your company if there's an issue. Now, the next question, next slide, please, Julian. Thank you. The next question is, so what's going to happen under our new administration? And the current thinking is unclear, frankly, but the current thinking is that the Trump administration is probably going to continue on in a general sense with permitting the FTC to go forward with its enforcement and privacy actions. Part of that is theorized because the FTC first began enforcement actions back in 2002 with the seminal case against Eli Lilly, and that was brought under a Republican-appointed commissioner for the FTC. Now, there's a caveat to that. The caveat is that in January of this year, on the 25th, President Trump issued an executive order that stripped the privacy rights stripped the privacy rights of non-U.S. citizens under the Privacy Act, I should say. And the effect of that is that there's now a question as to whether or not the recent agreement on Privacy Shield with the EU is still going to be effective. The EU has suggested that because the EU Privacy Shield relies on the Redress Act and not the Privacy Act, that more than likely Privacy Shield is still viable. However, there's been pretty much a clear shot across the bow of the Trump administration that further erosion of privacy rights of non-U.S. citizens could result in the Privacy Shield falling apart. The implication of that is that if your company does processing between Europe and the United States, that there are going to be issues with trading data back and forth because, and this is speaking in a general sense, the European rubric for how privacy and privacy rights is dealt with is very different than the U.S. right, and I'll just leave it at that. Now, next slide, please, Julian. The other interesting issue that we deal with in a legal environment sense is that there are obviously state actors that have been causing problems, and I would suggest that the United States, to some extent, has been accused of doing some of these things as well. However, of late, the one that's I think the most interesting is the Sony breach, which was done by the North Korean government, it is supposed. And the net result of that is that the employees of Sony sued their company, saying that the Sony Corporation had not taken appropriate steps to protect their information, and that cost Sony the minimum of $2 million and up to $8 million to settle the civil lawsuit, which was a class action. The other interesting thing that's going on from a, I guess you would say, a state actor standpoint is that we're not seeing many companies that sometimes are subject to state actor actions thinking that they are, in fact, subject to state actor actions. And I, without naming names, will point to certain law firms in New York that were recently breached that were supposedly working on questions of national security. So the point of all of that is that we not only have an enforcement portion that is a problem, but we also have, from a legal standpoint, outside actors with great resources coming into the data breach arena and causing problems. And Julian, if you go to the next. From a pure corporate environment standpoint, there are some other issues that we should think about too as far as what the legal environment is. In particular, and this is a little bit of an older case, is the AvMed case. AvMed, the short version of the facts are that some employees were working with laptops in a company conference room. The laptops had information, historical information about the clients of AvMed. Overnight, the computers were left in that particular conference room, and in the morning when the employees came back, the laptops had been stolen. This is an important case because it is an argument as to what exactly has to be shown to give a lawyer standing to bring a class action, and the latest theory that seemed to be gaining traction before AvMed settled the case was that there is an implied contract between a person's or a company's clients in the company that at least some of the money that the client is paying to the company is to be used for adequate security. The point being that if I can have an implied contract where you're supposed to protect my data and spend some of my money on security, that I can recoup that from the company if in fact we're breached. And like I said, that was settled before it ever got fully decided, and it cost AvMed approximately $3 million. Another corporate case that gives you an illustration of what the problems are and how they can arise is Target. Target was breached because they were having some work done on their heating and ventilation and air conditioning system, their HVAC system, and hackers used the access given to the HVAC company to get into the main portion of the billing records of Target, and that of course results in what we all know to be the Target Corporation lawsuits that have ensued. Similar but slightly different fact pattern is the Yahoo case. It's interesting from a legal standpoint because in this case they were breached, but the breach in this case resulted in the deal that had been struck for Yahoo to be purchased for $4.8 billion was subsequently reduced when it was not revealed during the transaction the extent of the breach. So the price of 4.8 was reduced by $350 million. Also interesting is that the chief executive officer of Yahoo agreed as a result of that issue to forego her $2 million bonus for the year as well as her right to options for the year. So you see ramifications for many different kinds of bad acts, if you will, for the companies. And then I just read this morning where Home Depot has agreed to pay $25 million to the banks to settle the case with the Home Depot breach. So that's where we are. We're in a highly litigious area. I will tell you that it's my perception that it is still an immature area of the law as to what exactly gives rise to liability. I think there are different types of bad acts that can create problems for companies, and some of which can't really be predicted. So for instance, accidentally sharing your My Documents folder on a peer-to-peer network by an employee is not something that most of us would think about as being likely the way we're going to get breached. So that brings us into the next question, which if you advance the slide, Julian. Cyber insurance. What is the environment for cyber insurance? And the answer is, as of today, there is no unified policy that is the industry standard that has been put out by the insurance, I'll just describe it generally as the insurance industry, that describes what a cyber policy is, what it should cover, what it should not cover, and that covers all of the bases. And so when somebody says, we want cyber insurance, as an attorney, the question I have to ask is, what are you trying to accomplish, and what is it supposed to help you to plan for? And there'll be a little bit more that I'll talk about with respect to that, but I think at this point I'll turn it back over to Julian.
Thank you, Drew. So what does it mean to be a cyber secure organization, or at least understand what cyber secure means within the organization? And for this, I'm going to turn to Ponemon again. Same October 2016 study about the characteristics of an organization for cybersecurity. And this is going across all the organizations that they have in their systems. And there are some unique characteristics that cross those organizations. First, that the organizations assess security risks as part of the core operations, that security is not an afterthought, it's a forethought. Secondly, protecting data proactively with both technology and processes. And the key is that this is not just a technology problem. There are other factors that need to be worked in. Application security is not compromised due to a rush release. So thinking of security first and foremost, investing the time and resources into application security, even if it means delaying a particular release. Third-party risk is assessed and audited. Well, this is interesting because assessing and auditing third-party risks takes time. And so putting that effort and time associated with third-party risk is also important. Insider threat analysis. What are your employees doing on the inside, and how can you best protect against insider threats? Interestingly enough, there are people seem to focus on outside threats, but there is just equally as much damage that can come in from insider threats. Real-time event management, event monitoring. This is important so that you are looking at things as they happen. And a broader category of information management and governance. So some of the things to think about here are keep what you need to keep and dispose what can be disposed. Rather than having your company become a dumping ground of information, delete and dispose and decommission what you can get rid of so that it doesn't become a cyber risk. Testings of backups and recoveries. A lot of threats, and I'll talk a little bit more about ransomware in specific later on, might be able to be resolved with solid backup and recovery processes. And then sharing of threat intelligence, and this is an interesting concept to put into a security posture for a cyber secure organization, but being able to anonymize and share that threat intelligence across your industry. Detection and recovery is also important, understanding the need for speedy detection and recovery. And speedy obviously is a word that can be changed depending on the critical severity of the system being breached. Really what we're talking about is a lot of time, resources, money, training, technology, and really applying that across the organization and learning from prior incidents so that you can better detect and recover. What all of this means, if you boil down these characteristics, is that these companies are taking a proactive and a reactive approach together for cybersecurity awareness. So let's talk a little bit about how do I even start with a cybersecurity program, awareness, plan, etc. Well, I'm going to quote Ben Franklin here. By failing to prepare, you prepare to fail. So the first step is obviously preparation. And what do you need for the preparation? Well, you're going to need the right level of resources. This is going to be a mix of technical, legal, and C-level resources. And interestingly, this mix of resources and the C-level, first of all, the C-level is important because you need to get budget and priority from the top pushed down so that the rest of the organization understands the need. Secondly, you need to be able to speak to all three of these areas of your company. And as Drew mentioned, he can be one of those resources, or people like him can be one of those resources that crosses those lines. So sometimes thinking about engaging outside help into the resources is also an important step of the process. In addition to thinking about, go ahead, Drew.
If I may add, just to that point, there are two things that can be useful in the what I'll call the post-litigation. We've had a breach, now there's litigation problem. If you've engaged an attorney to help you to set up your systems and processes, your policies and procedures, two things can be used. One, it is possible, I say possible, not that it's an absolute definitive thing, but possible that some of the work that you do can be covered under the attorney work product privilege. And that means that if going forward there's litigation, that to some extent there may be information that does not have to be disclosed as privileged. Now, I'm going to put an asterisk on that because at some point later on in the conversation I'll go back to that. But the other thing that it can help you do is, as a valid defense in some litigation, it is a valid defense to say we relied on advice of counsel as to how to address this issue. And to some extent that can help you, and I'm just keeping it non-technical, can help you to sidestep some of the issues as to whether or not you breached a duty of care that you would owe to the people that you're handling their data. And Julian, I'll hand it back over to you.
Thank you, Drew. So along that same line of policies, well, looking at your existing corporate policies too. For example, is there regulatory requirements on the data that you have existing such that you can start to segregate the most important information in your organization into other systems? So many times I'm engaged and I start finding out when you peel back the onion layers that the company is using their email server as a filing cabinet and just storing everything in email. And that becomes such a huge risk because of the number of access points that can go into an email server. So starting to figure out where can I store my most sensitive data, and email not being that storage medium. Another big component of policies is employee training. So this is not just the one-time onboarding employees, you need to be cyber aware, but periodic and ongoing training of your employees. I've seen some clients go through some really interesting endeavors where, as part of the training process, an ongoing training process, they bring on outsiders to actually run phishing attacks. And a phishing attack is essentially an attack where you come in through email and you get the user to click on something that they shouldn't click. And by spoofing these phishing attacks, they're able to understand which employees are falling for this particular attack. And it's in a controlled environment, so nothing negative is happening, but they're putting those employees through a mandatory training program so that they know what to click on, what not to click on, or how to tell whether they should be clicking on a particular link. In addition, thinking about your... Go ahead, Drew.
Sure. The other thing I was going to point out, too, is that it's great to spend a lot of money on having a policy and then a data breach plan and so on. But as Julian points out, if you don't actually train on it, then I think that you've exposed yourself to an argument as to why you didn't meet the duty of care that the company has. So, for instance, I'll call them the black hat attorney coming in to show that what you did is wrong and to sue the company in a class action says, well, it's great that you had a policy, but did you ever train on the policy? And if the answer to that is no, then that's a good angle for them. If the answer is, well, we trained on it one time when we first deployed it, but never looked at it again, that's also another angle. And so to help yourself and to help insulate yourselves, I think it is legally a great idea to train and to keep records of that training, and also to keep records of what you did to adjust based on what you learned from that training. Go ahead, Julian.
Thank you, Drew. So Drew's talking a little bit about putting together what I call the information governance plan around data retention. And information governance can be a big endeavor, but just thinking about that as you start and what you can accomplish with information governance, I think is key. Along the same lines, compartmentalization of data. So Drew mentioned the target breach and how through entrance point into one area, the bad actors were able to quickly move into other areas and move laterally through the organization. By giving employees access to only what they need and locking things down in a more siloed approach, you can break off those compartmentalizations and give yourself a little bit more advantage there. The other thing I see from compartmentalization is that I see too many places where keys to the kingdom are given to too many people. And this becomes a difference of getting employees to understand what they want to have access to versus what they need to have access to. People who want to have access to everything don't always follow the best data security protocols. So making sure you find that balance in that particular compartmentalization is great. Finally, think about your activity logs and monitors. You need to be able to track within your organization, but be careful. You don't want to be viewed as Big Brother. So letting employees know what you're tracking and how you're tracking or how long you're tracking, things like that might be approaches that you take. Also, remember that should an incident happen, you're going to need to have the logs and the information to analyze. There's studies going on right now that it's about a 6-month average before a breach is detected. So let's just say your logs are rolling every 90 days. Well, if it's about a 6-month average before a breach is detected and you detect a breach, but you don't have the logs anymore to do any analysis on it, you might be putting yourself in a bad situation. So I'm going to hand off to Drew here and have him talk a little bit more about where to start from the legal perspective.
The first question you have to ask, which I think is probably obvious to everyone, is, am I in an industry that requires some type of heightened security or some type of regulatory framework that requires me to do special things pursuant to, again, federal law? And instances of that would include, for instance, banking with the Gramm-Leach-Bliley Act, otherwise known as GLB, and it has particular questions and issues with respect to whether data has to be encrypted when it's at rest. And all of that is being driven from a top-down federal regulatory standpoint. Another one that is very similar is HIPAA and HITECH, which obviously is medical. There is a tremendously complicated, in my opinion, framework as to what can and can't be done in the medical industry and what the requirements are for systems in that industry. And I'll tell you, I don't delve into HIPAA and HITECH because I have a partner who seems to like that stuff, so I let him do it. So that's kind of the first question. Failing which, there's always going to be what I call a non-specific framework that I've been harping on, which is the FTC, which is what you're doing going to trigger the interest of the FTC as an unfair and deceptive trade practice, i.e., are you taking data, using the data, and not properly storing it or improperly disseminating it, and so on. So that's the first question. Do we have a federal framework? And then, because it's the United States, you get the added bonus of having to deal with your state-based regulations. I am personally in Florida, and I will tell you that there's not exactly a framework in Florida that governs everything, other than there is also in Florida, like most other states, what we refer to as a little FTC Act that gives the state Florida Attorney General the ability to come in and, just like the big FTC, take action when it thinks that an unfair and deceptive trade practice has happened. Now, interesting caveat to that, the state of California has a specific state law that protects the privacy rights of California citizens. And I have asked an assistant attorney general for the state of California whether California takes that law and essentially applies it across every other state. And the reason I ask that is it basically says if you are going to deal with California citizens, then you have to provide specific information on how the California citizens' information is dealt with and give them a contact person to tell them who at the company is able to address questions that the California resident has. And so the question presented to the California Assistant Attorney General was, if I'm in Florida, is California going to take the position that my Florida company, if it's doing business on the web, has to comply with the California law? And the answer to that was yes. California takes the position that if you were somehow dealing with California residents, that you have to deal with the Online California Act protecting our citizens. I can tell you that I have some questions as to the applicability and the constitutionality of that particular position, but nonetheless, California takes an aggressive position that you should at least think about. And I think that also has some other requirements. If you're doing a lot of business in California, even if you're in, for instance, Florida, New Jersey, DC, wherever, you should think about the extent to which you want to comply with that particular act. Now, other issues. Are you doing business internationally? And I think you, as all people that are dealing with tech issues, realize that where data is sometimes hard to know, but there are issues implicated when data is stored overseas. So for instance, the easy one, and I talked about this a little bit earlier, with respect to the Privacy Shield issue and the European Union. If you have information that you're transmitting to Europe, or you have subsidiaries that are doing business in Europe, you need to think about whether and if you're allowed to bring that data back to the United States for processing. You also have to think about if there's a lawsuit, are we going to be able to bring that data back to the United States easily? Are we going to have to comply with U.S. subpoenas and so on? That's another case that I'm not going to get into the details of, but that's an issue. Another issue, if you're doing business in China, China has taken the position that data that is in China belongs to the nation of China and that you are not permitted to take it out of the country without their permission. Now, whether and if and to what extent that's dealt with and how they deal with it as a matter of fact is something beyond this question, but it's something to think about. All of these then feed into the question of, well, what should we be doing in order to build our systems so that they comply with law, and what are we doing to make sure that our systems are properly secured and properly usable, kind of conversely, in this overall scheme? That's the first question
Drew,
you have to ask yourself. Sir.
Drew, just to tack on to that, one thing to remember is that the rest of the world doesn't view data like the U.S. views data. The rest of the world takes a very different approach to data privacy and what is considered very important and private information. So if you do have an international footprint, you really need to consider the privacy aspects associated with things, because that can change what the level of criticality of certain data sets are if they should get breached.
Agreed. The next slide.
Next slide. Yep.
So here's the other thing to think about. When you're building the system that you're building, and I mean that in a legal sense, in a policies and procedures sense, the other thing you have to ask is, what's going on with our contracts? And I mean that in a very broad sense, the word contracts. So the first question is, what contract do we have with our clients? If our clients have hired us, what are we responsible for doing with them? And when you sign the contract with them, is it your contract or is it their contract that you're starting with? In the contract, is there language regarding who bears responsibility if there's a data breach or a data incident? Is there, what you normally see, is there a limitation of liability? Is there a limitation of warranty? Are those okay with us? Can we comply? If we have multiple clients, do we have a contract that says, which you don't want in most instances, I'll tell you, if we have a contract with a client that says that the client gets to control the event if there's a data breach that involves the client's data, you don't necessarily want to agree to that, because if that client's data is breached, more than likely other client data has also been breached, and you don't want to have the client controlling the event by contract when that also affects your other clients. Similar questions with customers. Have you, and this goes into some of the earlier FTC actions that I was talking about, when you have a contract with a client, be it express or implied, and understand that a contract can also be your terms of use, your end user license agreement, or even, as I said with respect to AvMed, an implied contract based on certain understandings in the agreement with the customer, then the question is, what have we agreed to? What have they agreed to? Have they agreed that we can use the information that they provide to us for any purpose or for only a limited purpose? Are they going to be a European resident? Are they going to be a California resident? These are all the issues that you need to think about when you're engaging in what I call traditional customer work. And I'm using customer and client slightly differently. I'm assuming that there are going to be some, what I will call, high-level clients that you're doing information type work for, and then you have what I'll call the more retail type customers that you might be doing work for. Now, with respect to vendors in this case, the way I'm using the word means the third parties that come in and help you do what you do, but aren't part of your company. And that can be as simple as it's a software provider that provides cloud hosting for X, Y, or Z, or is perhaps hypothetically a white hat hacker that we engage to do penetration testing. The question is, what are the contracts with them? And please tell me you don't do this, but when you engage them in a contract, does it have kind of a very generic description of what they're going to do, or does it include lots of jargon that nobody really understands, including the people that have handed you the contract? Instead, the contracts should generally have a very good description of what they're going to do, what the limits of what they're going to do are, what the access controls are in place for when they do it, what their policies are with respect to client data and information. Are they going to live up to your contract requirements with respect to the requirements of your customers or your clients, and so on. And then in all of this, overarching all of it, is the question of, well, what about the insurance that they have for data incidents or cyber incidents in general? And if you would pop us over to the next slide. I've talked a little bit about each of these in the first slide, so I'm going to go on past. One more slide, please, Julian.
Great. I think that's going to hand it over to me to talk a little bit about response planning. Anything else you wanted before I jump on?
No, sir. Go ahead.
Great. So all good things start with a plan. So what do you do from a response planning? These high-level bullets shouldn't be surprising to you, but let's talk a little bit about what it means. First of all, developing the plan. This is not a technology problem only. There was an individual once who mentioned in a conference that his end client told him that they spent this hundreds of thousands of dollars on a particular type of technology to make themselves more cyber secure. And when he went and peeled back the onion layers, the configuration of that particular technology and the fact that nobody in the organization knew how to use the technology meant that it was a multi-$100,000 piece of doorstop. Really didn't do much of anything. So it is not a technology problem alone. This is people, process, and technology together in a response plan. NIST Cyber Framework is a great place to start for a response plan. Your technology teams are going to be able to dissect and delve into this information very quickly. But one thing to note, that this is really more of a floor. It's not a ceiling for cybersecurity framework. And really, and I've mentioned this before, your plan has to have buy-in from the top. If you are going to become a more cyber secure corporation, you're obviously going to have some cultural changes, whether that's how long people are getting to retain and hold data, or how easy people have to get access to certain systems, or how open to the keys of the kingdom it is for various C-level employees who may have been there from the very start and don't necessarily need it. Going back to what I said earlier, it's about what you need to have, not what you want to have. So really that buy-in from the top for the plan development is important. Once you've got your plan developed, you obviously need to test it, and they call these tabletop exercises. And really what you're doing with a tabletop is going through and testing your response scenarios. One of the most important things to come out of tabletops is really the metrics. Are they within the acceptable limits of what you're seeing from a time perspective, from an effort perspective, from an action and activity perspective? And secondly, making sure your redundancy exists for your resources and your systems. For those systems that are most critical, you probably want to have redundancy such that if an attack happened, there's a way to bring it back up fairly quickly and easily and get back to business as usual as quickly as possible. I talked a little bit about backup and restore of data for testing. Well, here's where that becomes really important with ransomware exercises. And ransomware events, for those of you who may have heard the term but don't know quite exactly what it is, generally speaking, it's when your systems are breached in some form or fashion and the data on your system is locked down or encrypted such that the only people who have the decryption key and can get access to it are people you have to pay using Bitcoins or some other payment method. And so they're holding your data for ransom, and that's why they're calling it ransomware. Well, interestingly enough, the easiest way to get away from a ransomware issue is to restore the data back to the previous day or whatever your time frame is, and understand what may have changed in that time frame so that you don't have to pay the ransom. You can fix the plugs and you don't have to worry about data being no longer accessible. And remember that this is a living plan. You really need to revisit and refine the plan, and there's a couple of reasons for that. First of all, new threat vectors, which are new ways to get into your organization, are evolving daily. And so thinking about keeping this as a living plan and document to tailor for new ways and new scenarios is going to be important. The other thing I would bring up here are that new systems and applications are coming online all the time. These might be systems and applications within your organization that you are doing to better deliver services to your clients or other businesses, if those are your clients or whatever the case may be, or something that's really starting to become top of mind these days, which is what I'll call the Internet of Things. And essentially that is a network of billions of connected devices. Things might be in your home, such as your refrigerator or your oven. Things might be in the offices. Things might be in the air, or things might be on you, wearable devices like Fitbits. All of these start to become additional endpoints for potential data security issues and breaches. So it's really important to revise and revisit the plan because of this. And of course, if a breach happens, it becomes a chaotic time, but remember to follow the plan. If you've done your tabletop exercises, you can help make this a little bit easier on your effort, but make no mistakes, it's going to be a difficult and challenging time. You know, it's important to think about engaging outside counsel like Drew and his team. These people are very experienced with taking these scenarios and helping try to make the process run as smoothly as possible. You also need to consider post-breach the downstream litigation that can typically arise. As Drew mentioned earlier, there are multiple scenarios where there was downstream litigation that cost the companies millions of dollars. So make sure you're thinking about what types of information may need to be preserved for downstream litigation. Also, consider whether you might need to bring in an expert. Maybe your incident response team is not the same as your expert team that are going to come in and do an independent validation of what they're finding and then be able to testify it for downstream litigations or investigations or anything like that. At this point, I'm going to turn it over to Drew so he can talk a little bit more about what happens with engaging outside counsel post-breach.
Thank you, Julian. A couple of things that I think should be mentioned. In addition to having an attorney, I think you should also have considered in creating and drafting your data breach plan whether and if you need a outside critical communications expert on standby so that if there is an issue that you can step through quickly the process of retaining that person or firm and having them help you, having them already know a little bit about the company and have an idea of what the issues are and the sensitivities are. And so you want to have an attorney, you want to have obviously an outside critical communications person, and then this is where I think you hire a person like Julian, which is in advance you hire an expert to come in and be online and to understand what the company is all about from a tech standpoint before there's actually a breach. Part of that is because when you do the tabletop exercise, those three people should be engaged to go through the exercise with you. And that then gives you the practice of how do you actually work together, how do the personalities fit together, what are the issues, and how do they think about things so that you actually are acting as a team versus kind of taking it cold. This then helps you to save time when there actually is an incident. Now, going back to the issue with respect to outside counsel, one of the questions is always, are we going to claim a privilege under work product or to some extent attorney-client communications, or are we going to waive that particular privilege and therefore provide it to other parties? And by other parties, I'm generally referring to law enforcement of some sort, be it an attorney general for the state, be it an actual law enforcement officer, a federal law enforcement officer, and so on. And so that is a question that should begun to be asked and talked about at the beginning. I think the general answer is most attorneys are going to tell you we're going to keep the privilege until we decide to waive the privilege. And that is a calculation that is made upon what the issue is. Now, that also brings you to what I've already talked about, which is at what point do you engage law enforcement? Do you engage them immediately? Do you wait? Do you make decisions on the fly because you don't have a plan? And I think the answer is that part of the tabletop exercise will include a discussion of, under a particular fact pattern, this is what we think about hiring calling law enforcement and telling them we have a problem. So if it's a time-sensitive issue, so for instance, if you've had an impersonation breach where a person has impersonated an employee with authority to transfer money, the money has been transferred, do you want to immediately let law enforcement know? And the answer to that is probably, kind of depends on the facts again, but probably because your best hope of getting the money back in some instances is going to be with law enforcement authority trying to track the money, in addition to other things you do, such as reverse wires and so on. Now, so that's all a way of saying you should start thinking about that in advance of actually having any type of breach go on. The other thing I'll point out too, and this is more of a technical issue, resist the urge to pull the plug until you've talked to both the attorney and talk to the outside expert, such as Julian, so that they can have some input, I should say, as to if we pull the plug immediately, have we lost all the information and the ability of the experts to go in and decide what areas have been breached or not, and or can we use their activities to help trace back to where their location might be, those types of things. There's a lot of thought that has to go into it, and it should not be, if you can avoid it, a knee-jerk reaction. Julian, back to you.
Thanks, Drew. And following up on that regarding law enforcement, going back to what Ponemon talked about regarding the characteristics of mature cyber organizations, they're ones that share information. And sometimes contacting law enforcement helps that activity because law enforcement knows what else is happening. They might be able to provide you information about, oh yes, this particular type of breach is coming from this particular type of area. We've seen this before. So it's another thing to think about there when it comes to law enforcement. And Homeland Security is another department where they are helping companies share information anonymously through Homeland Security and then distributing that to other organizations and entities so that you get an understanding of what's happening out there in the world. So let's talk a little bit about, I've been breached, and now what defines success? And I know it's very hard to think of success when you are presented with a breach scenario. But remember, we're really starting to get in the world of not if you get breached, but when you get breached. Now, the severity of the breach may extend across the gamut, but thinking along those lines, there are ways to define success in breaches. Thinking about how well did your response plan hold up? Were you able to follow it? Were there big holes in it? I'm sure it's not going to be 100% perfect as soon as you get a breach. Things do get a little chaotic. But how well did the plan hold up? How well did your tabletop exercises hold up? Another big question is, how did your staff react? Were communications about the incident to the staff sent appropriately? Was business continuity followed by the staff, or was it a complete shutdown of the entire organization? How effective were the updates to public and other individuals out there? Sometimes you can contain a breach and keep it quiet. Other times you can't. It all depends on the scenario. Were you able to get to systems and data recovery quickly? And again, going back to the ransomware example that I talked about, if you have robust backup and restoration activities in place that are tested, you may quickly be able to get past a ransomware incident without having it affect your systems for too long. Another thing to think about is critical system redundancy. Did I have redundancy for those critical systems that if they got breached, there was able to be a level of business continuity? People often think about policy changes as a part of a breach or incident response. And just using Drew's example earlier, I wouldn't do a knee-jerk reaction here, and there might be a couple of reasons why. So for example, let's say you identify a breach and your analysis post-breach indicates that the entry point was through a USB drive that came through somebody's computer. Now, you may want to take the approach of saying, I'm going to shut down all USB accesses on all computers. That's one way to prevent the breach. But you have to remember that your employees, from an information governance and workflow perspective, may find a way around that protocol that is actually worse for you. So, for example, they might try to use less secure methods to transfer and exchange data. For example, like Drew discussed during the LabMD scenario, where somebody was using a file sharing application. Now, that might not necessarily be a scenario because they shut down the USB devices, but remember that your employees will try to do what they can do so that they can get their job done. So shutting down USB ports without providing some other method that's secure to transfer information might not be a good approach. Drew, are there other factors that we want to talk about that define success?
Yes, actually. I think you knew I had a comment. The question at the end is always going to be, has what we've done, is it legally defensible? Is it legally defensible in two senses? The first one is, we got breached, but did we try and do our best? Did we do a reasonable job? Have we handled it in advance of the breach in an appropriate way? The part two of that is, it doesn't end there. The part two is, did what we do after we found the breach, was it consistent with what the standard of care would be on how to fix the problem? So, for instance, did you make decisions that were consistent with best practices? Did you write that down so that you could know why you made particular decisions versus I can't remember why we decided to do that? And so, for instance, your lawyer probably is going to be a pretty good scribe, or perhaps somebody who is actually assigned as the scribe role will be the person who's assigned to write down the thoughts and the reasoning for, we did this because. And while we didn't think there necessarily was a good answer to this, we chose to do A and not B, and the reason is this. And so you follow the pattern of making sure that you're making good decisions, that you're recording what the decisions are, and that you're getting the input of the professionals that you need. Those are the things that are the hallmarks of a legally defensible outcome. We got breached, but we tried not to be breached. And then once we were breached, we actually acted in such a way that we followed our plan, we worked our plan, and we've adjusted now further because of that. The other thing I'll point out is this is critically important because, and I talked about at the very beginning of this, the FTC Wyndham case came about because the Wyndham had been breached multiple times, and the FTC more or less, and this is putting it in very simplistic terms, said you've been breached too many times, that's not reasonable. And the point of that for this point is if you've worked your plan, you then have to react to the plan, and you have to make your lessons learned applicable to your organization, transmit the information, and make appropriate changes so that you're always consistently updating and working on how do we respond to the reality in which we are, what is our history, have we fixed the problems we had in the past. Julian?
Thank you, Drew. We are at the end of our slides for this presentation, but we do have some questions from the audience. Drew, do you want to take the first question?
Sure. The question is, what is reasonable security, or what is an industry standard for security? The answer to that is, I don't know. And the answer further is, I don't think anybody knows. I think it is always going to, at this point, be a question of who are you, what are the details of your situation, and how can we decide on whether what you did, is that a valid response? Is that something that is reasonable in the situation? I don't think there's any enforcement agency or, frankly, any body of law that says specifically this is the standard of care and this is what you have to do to take reasonable steps for security. But at the same time, it's the application of what I call old school tort law in one sense, or in other sense, application of contract law to determine whether and what you did, was it reasonable in the circumstance. How about you, Julian?
Thank you. Yeah, there's another question here about the what are some of the new technologies that can help prevent and detect breaches? So I'm glad somebody asked this. This is an interesting question because we're starting to get into a world, for those of you who've seen Minority Report, that is becoming a little bit more like that now. We're certainly not there, but at the same time, there are technologies now that are analyzing patterns and trends of behavior and able to understand or at least point out when behavior changes from a particular employee. If a particular employee's behavior changes on the frequency of the external emails that are sent and received, not the content, but the frequency, that might be an indication that perhaps the individual is frustrated or may want to leave. If you layer that on top of engines that are now trained to tell the tone and inflection in communications, saying something is a positive communication or a negative communication, and you see that those communications are starting to increase in negativity, that may bubble up the scenario a little bit higher. And then, of course, if you layer that on top of some of the other systems that are out there that track information like card swipes, if behavior starts changing of employees, again, it starts to bubble up scenarios. Now, again, we're not in a place in the world where the technology can predict the future, but at the same time, it can start to identify some patterns and behaviors. And I think that's really some of the new technology that can help prevent and detect breaches. Do we have time for one more question?
I think we're out of time.
Okay, great. So at this point, I'm going to hand it back over to David to wrap us up.
Thank you, Julian, and thank you, Drew. I think that was a pretty interesting conversation for our audience. And thank you, audience, for attending. As a reminder, please take a moment to complete the brief survey that will pop up on your screen in a minute. Also, within the next few days, you'll receive a link to the recorded event. And for any questions you asked that weren't answered by the presenter, someone will be reaching out to you shortly. We hope you found this webinar informative, and we look forward to having you join us at our next event. Again, thank you.